Good afternoon, everyone. Thank you for joining us today for a presentation by the Maryland State Bar Association Family and Juvenile Law section on the handling of domestic violence litigation before and after the COVID-19 court closure. I'm Andrea Terry, the Director of Learning for the MSBA, and I'd like to thank this section and today's presenters for putting together an information-packed hour on a topic that we've had many requests for over the last several weeks. And given that we've got more than 160 registrants for today's program, there's obviously a great deal of interest in this topic. To pose questions to faculty, you may type them into the YouTube chat channel, or you can email them to crisel@msba.org, the email address at the bottom of your screen. Faculty will try to do their best to get to as many of your questions as possible. They are holding questions to the end of their presentation. Your faculty today are Deena Hausner with the House of Ruth, Laure Ruth with the Women's Law Center of Maryland, and Mark Emden with Emden Law. Again, we thank them for their work on today's program. And with that, I'll turn it over to Deena Hausner.
Good afternoon, everyone. Andrea, thank you so much for the introductions. Again, my name is Deena Hausner. I'm the Associate Director of the Domestic Violence Legal Clinic at the House of Ruth, Maryland. And for a few more weeks, I'm the immediate past chair of the Family and Juvenile Law Section Council of the MSBA. And I want to thank you all for joining us today. I'm going to turn it over to my co-presenters to say a little bit about themselves, and then I'll give a quick layout of this afternoon's presentation. Laure, don't forget to unmute. Technology.
It's all that. Hi, I'm Laure Ruth. I'm the legal director at the Women's Law Center of Maryland. As some of you may know, we are a statewide legal services agency, and we do have protective order projects in various jurisdictions, as well as somewhat statewide, mostly the Baltimore area. And we partner often with the House of Ruth, and I just want to thank the MSBA for sponsoring this today, because I think it's really important information for you all to have. Thank you.
And Mark?
Hi, everybody. My name is Mark Emden, and I run the law firm of Emden Law in Montgomery County. And I've represented petitioners and respondents throughout the state, and it's a privilege to be here today talking with all of you.
All right, thank you. So over the past couple of months, we have all dealt with a tremendous amount of change in the way courts have had to address domestic violence protective order cases as a result of the impacts of COVID-19. And now that the courts are preparing to reopen, we wanted to offer really some thoughts and suggestions and food for thought on issues that we are all likely to encounter with our cases. And if you learn nothing else today, I think it is all of our hope that you'll understand that none of us really have all of the answers, and that we believe that the situation with the courts and how they handle protective order matters is likely to change, just as it has during the past 7 weeks during the partial court closure. So this is really just an opportunity for us to share some tips with you that we've gained from our practices over the past couple of months, and what we think all of us need to be considering and thinking about as we re-enter the courtroom, whether that be in person or virtually. So we've broken our remarks this afternoon into kind of 4 main categories, talking about the personal safety and welfare of ourselves and our clients, managing our clients during this process, and then ideas about in-person hearings as well as virtual hearings. As Andrea mentioned, there's an opportunity to ask questions. We'll do our best to weave them in as they come up related to what we're discussing at any given time, but our plan is to leave a large chunk of time at the end of the remarks to answer as many questions as we have time. Also, we do have a document that we prepared that summarizes a lot of what we'll talk about today. So if you don't want to take feverish notes, that will be available to everyone after the webinar this afternoon. And so with that, I'd like to turn things over to Laure again to talk about attorney personal safety and welfare and clients.
Thank you, Deena. I advocated in our preparation for this event that we title this document we're going to give you, "It's the Wild West Out There." with a subtitle of "Nobody has a clue what's going on and it's going to change anyway." But that was too long and I was voted down. However, it does, I think, signify the theme of this, which is what we have found is that it's very jurisdiction specific. It is sometimes judge specific. It is circuit court versus district court specific. And what's new and different for attorneys is all of these additional considerations, both for yourself and as the communicator with the court with regards to your client. So in terms of sort of trying to set your own mind at ease and deal with your own stress level, our biggest takeaway of what we've learned over the past few months is call the court's office, call the clerk in advance, and call them often if you have to. Because, the Women's Law Center and the House of Ruth and other agencies that do pretty much only protective order work in some contexts have learned that things change sometimes the afternoon before your hearing is scheduled. They change sometimes that morning. And you have to be the information flow to your client. So if you don't know something, call, try and find the answer. There are pieces that are anxiety provoking, like, my attorney, one of our staff attorneys yesterday was saying they don't get the connection information of Skype for Business until an hour before their hearing. So they don't have time. They have to know how to use Skype for Business and have taught it to their client, before their scheduled hearing time to try and smooth out any of that technology stuff. And I'm not an IT expert. So as my office would attest to, it's not always best to have to come to me for your IT needs, and nor some of our staff, but here we all are. And for solo practitioners in particular, if you don't have an IT department, this can be really, really challenging. So one of our other sort of personal safety and welfare ideas is to cut yourself a break a little bit, and accept that you don't know all the answers. And that's why I liked my subtitle, which is nobody really knows what's going to happen anyway. So we are all in the same boat. And I think that the court in a lot of ways is in the same boat too. So we have watched them try to figure this out on mammoth proportions and do the best they can to provide justice to people. And it's perfectly imperfect. The concept of lawyers having to say to their clients, I don't know, is really, really hard for lawyers to feel good about, which is perfectly understandable. But just realize that that is the right answer right now in some instances. We still know the law, and don't forget that you know the law in the confusion of trying to maneuver through all of these additional pieces that are happening. Take a step back and realize, wait a minute, I'm still an expert on the law. So there is important information I can provide and counsel and advocacy to my client, even in light of all this noise going on about everything else that's happening. The other thing you're going to have to do if you are called into court in person, which is and does happen. We have projects in Carroll County. They have never really stopped. We've been having hearings there, periodically in both circuit and district, not all remote, some remote, not all remote. The same for Baltimore County, where we have a practice. They've been some remote, some not remote. So you've got to assess your own comfort level and safety feelings about going in person to court. And then you also have to assess your clients. And that can be an advocacy piece as well. So I think that the courts will be responsive to an attorney saying, I know you want to do this one in person, but they have an 85-year-old in their home and they don't want to be exposed in the courthouse. Can we please do this by teleconference or video? And that's an assessment that you need to make in the best interest of your client based upon their health, their comfort level of being in the public, and your comfort level of being with them, quite frankly. So the other piece of this is you and your client together, which Deena's going to get into further later. But all of that is something you need to consider, especially if you're being called to go to court in person. And there's a hard piece of this, which I don't think any of us know the answer to, is if we have been told by various courts who've had town hall meetings and whatnot that all personnel are going to be wearing masks, that you will be required to wear a mask. So I suggest to you that if you are not a person who has been wearing a mask and are not used to it, you should get used to it, because they are pretty clear that they will not let you in the courthouses if you refuse to wear a mask, you or your client. We do not know the answer to whether they will then dismiss your case for failure to appear, you or your client, or whether they'll say, look, we'll postpone, but when you come back, you better wear a mask. I don't think we know the answer to that yet. They will be temperature checking at most of the courthouses, not all of them. And just as a little side, I don't know if my staffer from Carroll County is listening, but they were testing out yesterday on her their brand new plexiglass touchless face thermometer, and her temperature was 112 degrees, which we thought was rather concerning. But it gave us all a good laugh about the imperfections that we are bound to be encountering as things go forward. So, part of this, I don't know. I don't have an answer for you right now. Client X is the adjusting your own expectations and realizing that you're not the only one experiencing this. So if you have if you have judges who say, I'm not doing EFM in a final protective order, or if you have judges who say, custody, we're not doing custody and protective orders right now, you're probably not the first one who's experienced it, and you won't be the last one who's experienced it, but you've got to manage that, then as necessary. It's just that we don't know. So we received two pieces of information that I will impart to you from the same person, as it turns out, but Deena got half the information and I got the other half, I think. So I have been trying to figure out how many cases are scheduled starting June 8th. Lisa Jordan from MCASA reported several weeks ago that Wicomico County, which to me is not a large county, already had 200 cases scheduled for that first week. We learned this morning that Baltimore City District Court has 1,200 cases scheduled in District Court, Baltimore City, for that first 3 weeks. And they have a plan, but the plan, quite frankly, does not give you a lot of time to try a case. And I think that may be the biggest challenge that we as lawyers are going to face is if a judge says you get 15 minutes, go, how are you going to prove that violence has occurred, that she's in fear? How are you going to manage custody decisions, emergency family maintenance? And it may not be possible. And you may end up having to then, if you're in district court, filing for an appeal to circuit court where maybe you'll get more time. But I don't think we know that yet. And that's a stressor for all of us. So you need to be prepared for that. And that's, if I could say my biggest takeaways from my section are call the clerk, keep calling him if you haven't heard, understand that you're the IT specialist if you don't have somebody else who is an IT specialist for you. There are different ways that different courts are using to submit evidence. We have had final protective order cases go forward remote with full evidentiary hearings where you may have a police report, you may have medicals, you may have pay stubs you want to put in for EFM purposes, or child support guidelines that you've run to try and approximate EFM. You need to know for each individual jurisdiction, or maybe even each individual case, how you're going to do that. And I'm not talking about, there's more of this, there's an overlap to all of our sections. So forgive me if I'm speaking about what Deena and Mark are going to talk about, but my section is about self-management. And so, I think lawyers tend to be the people who like to be more prepared rather than less prepared overall. So as much information as you can obtain while still having to say to your clients, I don't know, is where you're going to end up in these. And I think Deena is right when she says, we predict it will change. So today they have a plan, but 5 days in, they may say this is completely unworkable. We've heard in Baltimore County, They're going to call cases at 9, 11, 1, and 3. They're going to have 4 cases per courtroom at those 4 separate times. Some courts are allowing all 4 cases to sit in the courtroom, just socially distanced on the rows. Some courts are making everybody stand out in the hall, and so it's only one at a time. Some courts, I mean, there's a lot, and I don't want to step on their toes, so I won't say more, but I, those are my takeaways. It's call the clerk early and often, set your expectations reasonably for yourself and your own well-being, and realize that you are the communicator for IT and any other issues between the court and your client. I don't know how my time is, Deena, and I don't know if there are any questions.
So I think we're starting to get some questions. I just want to remind folks that even if we end up answering your question at the end, you don't have to wait until the end to start asking them. So feel free to start sending questions along as you think of them, and we'll do our best to either answer them throughout the course of our comments or at the end. Laure, I was wondering if you could speak to, we did come into some information, you and I, earlier today about what the district court is going to be doing to sort of share information with the public about when cases are scheduled.
Sorry, you're muted, Laure.
Someday I'll get the hang of this and then it'll all go away. We did learn earlier, again, that, and I'm sorry, I told Deena I would mention it and I forgot, that Judge Morrissey, who's the head of the district court of the entire state of Maryland, indicated that the court is working on some sort of link that on the courthouse websites that would take you to a docket listing of each court, so that you could say, I think I might have a case on, in New Catonsville on Thursday, but the court still hasn't called me. I can't get through to the clerk's office. What do I do? You might be able to go on that link when they get it up and running to see if your case is listed. And hopefully that will help with some of this unease that the lawyers are feeling about not knowing what's going on. And to be quite honest with you, we have had cases that were set in for, let's say June 15th, and then we get a call yesterday that they've actually set it in for today. And we haven't been notified and don't know that it's going to happen. So don't think if you've got one set out right now I would be checking these cases every day, quite frankly. For my own comfort level, I would be checking them every day. So it's a great thing if Judge Morrissey can get that up and running. There is right now, the time frame is as soon as possible, but no date given.
Right. And we did have a question come in, Laure, that I think was a result of one of the things that you mentioned. Have there been any judges who have refused to agree to a remote hearing request, either by an attorney or by an unrepresented litigant? For my part, I will say I haven't heard of that, but just because I haven't heard it doesn't mean it hasn't happened. Right.
I have also not had that happen to my knowledge. There is a weekly phone call of DV service providers, such as the House of Ruth, that we have been on from the start, where we essentially share stories to try to learn information and know what's going on in different counties. And I have not heard that. But Deena is right. Just because we haven't heard it doesn't mean it hasn't happened. My suggestion about that is, if you're not comfortable taking something to a court about process, email me, call me. We would certainly consider trying to be the communicator for you. I think the courts are actually really, really, really open right now to suggestions. And I think that they are willing to work with people. And I will say, as my sort of follow-up to this, that what I have learned in sitting on town hall meetings and listening in and being in meetings with judges is that they will grant postponements liberally. If your client is sick, doesn't feel well, the court wants an in-person and you don't, ask for a postponement. And the other thing, and this goes broader than protective orders, is if you reach a consent, call the court immediately, and they will do it remote and put it on the record. So in all of your family law cases, we are hearing overall, if you don't have a court date in 2020 right now, you're not going to get a court date until 2021. And so they are happy to take your consent, your agreement, your settlement, whatever it is. They can divorce you on the phone. They can do a lot. So that's bigger than protective orders, but they know they have a tremendous amount of volume. And I think the biggest volume is actually protective orders. And so District Court Baltimore City did say they think it'll take 3 weeks of doing only protective orders at East Side to catch up.
And to your point, Laure, I think that if you are involved in a protective order case and you come to a consent, you can also call the court and ask if it can be assigned to a time for you to put the agreement on the record remotely. My sense from the meetings and different presentations that I've been a part of is that the courts are looking for opportunities to clear cases out of the dockets as expeditiously as possible. So if you are working with an opposing counsel or even with, an unrepresented litigant, you come to an agreement for a consent protective order, notify the court and see if they can get you in for an expeditious remote hearing.
Yeah. And Deena, I see a question from Jeffrey Schultz. I was talking about all kinds of hearings that if you reach it, isn't that what he just asked? Oh, that
right.
that they're being set earlier was his question. The ones that I know that are being set earlier than we knew are protective order hearings, temporary protective order hearings. So this is because, as you know, right now, and until July 20th, if I read Judge Barbero's order correctly, all initial protective orders are brought at the commissioner's office. And then they are getting set in for a temporary protective order. Some commissioners are saying, we're going to set that in for June 8th, 9th, 10th. But then the district court judges are reviewing those. And if there is a weapon involved, a request to vacate the premises or custody, the district court is pulling them and saying, no, we're going to hear those earlier. It's less relevant now because June 8th is only a week and a half away. But early on, let's say March 20th, you got an interim and it was set in for the temporary on June 8th. But meanwhile, there's no decision about custody or there was a weapon involved. They would pull that and say, we're going to hear that, March 30th instead of June 8th. But right now, that may not be as much of an issue because we're getting close to that June 8th date. But they were pulling the late set temporaries to earlier dates. If that answers Mr. Schultz's question.
All right, thanks so much, Laure. So I'm just going to spend a couple minutes talking about some new considerations for working with your client during this time, and then turn things over to Mark. This probably sounds obvious and something that most of us try to do anyway, but I think now more than ever, it's really important to make sure that you have up-to-date cell phone numbers and email addresses for clients. And the reason being is that particularly if you're doing a remote hearing, you may need a way to communicate with your client behind the scenes. I had this happen recently, not in a domestic violence case, but in a scheduling conference where I needed to confer with the client while we were live in a teleconference with the family law magistrate. And so it was important that I had up-to-date contact information. And so talk to your client in advance. If we need to have a little sidebar either in the courtroom or while we're on a video or teleconference, what's the best way for us to do that and make sure that you have a reliable method. And the other thing, especially for video conferencing or teleconferencing, is talk to your client about how to behave. I think a lot of us are used to telling our clients how to behave when they're physically in a courtroom, but it's equally, if not more important, when they're on a telephone line or a video conference, particularly because we're finding that in many situations, sometimes the judge will have to sort of quote unquote step off the bench and put the parties on hold, but then the parties and counsel are left sort of on this open phone line or open video conference. And there's a lot of opportunity for crosstalk. And so you want to make sure that your client is prepared to stay away from that and sort of just how to conduct themselves during the hearings. Don't forget that if the court hearing is remote, the court is still required to provide an interpreter. So if you're working with a client who requires interpretation for the hearing, make sure that you've contacted the clerk's office in advance to make sure that will be available. Most of us, when we're in the courthouses doing protective order cases, there's at least a Spanish-speaking interpreter kind of on call at all times. That may not be the case anymore. And so you want to talk to the clerk, and especially if you need a language other than Spanish for your client, talk to the clerk in advance to make sure that that is arranged. If you're going to be in court, and Mark will talk about this a little bit more, you also need to have ways of communicating with your client. You know, sort of gone are the days where we lean over at trial table and whisper something in the client's ear, or, you know, have a quick conference away from the trial table. It's going to be really hard to do that with masks on. It's going to be even harder if we have to stay 6 or more feet away from each other. So again, being prepared to text or email with your client, even if you're in court, or have some paper and pens with you, or asking your client to bring those so that you're not having to pass those back and forth. You know, one of the big themes of this as we were preparing for today's presentation is we don't know what we don't know. The other thing that we don't really know is how quickly some of these cases will be resolved. Even if you have a hearing date for a temporary or a final protective order, there may be all kinds of reasons that that hearing date will be moved to a later time, either at your request or for some other reason. And so one of the things that has been particularly hard to say to clients is there is no immediate legal recourse for you right now. And particularly in the context of protective orders where safety is at issue, or someone needs to get back into a house to pick up their belongings, or the other parent is withholding access to the child or something like that. You know, emotions get very high. And so clients may need a little bit of extra hand-holding during this time, particularly where we know that we may not be able to secure immediate legal remedies for the clients. One other thing to really keep in mind and prepare for is when you're in these hearings, whether it's remote or in person, what we're hearing from various judges is that they're going to take over the questioning of the clients or the witnesses, of the parties or witnesses, in an effort to make things move along more quickly. So don't forget to prepare with your client for that possibility. I know it's frustrating when you've taken, you know, several hours to prepare a whole direct exam and the notes, and you've prepped the client, you have a good flow, and then you get into court and the judge says, well, I'll just ask the questions and you can let me know if you have any follow-up. When that's happened to me in the past, it's really thrown me for a loop. And I think often what happens is not all the information that you had hoped to present to the judge actually comes out. And so you may need to sort of have a two-part prep with your client of here's what's going to happen if I ask you the questions, and here's what needs to happen if the judge asks you the questions. So we are preparing at the House of Ruth for that to happen in quite a few cases. And I would recommend that you all be prepared for that as well. Another consideration that I think is not something that we had to talk about as much prior to all of this is what's the expiration date for your protective order, for the final protective order now. So typically when we go into court and the client has obtained or a party has obtained a temporary protective order on day one and they're back in court 7 days later for the final hearing, usually unless you've worked out a shorter time frame than a year, the expiration of the final protective order is a year from the date that you appear for the final protective order hearing. But what we've seen come up in some of the hearings that we've participated in during the last 2 months is if you've already had a protective order in effect for a month and a half or 2 months, or in some cases now it may be 3 months, is the final protective order expiration going to be a year from when you appear in court for the final hearing, or is it going to be some other date? So that's something that you want to consider in advance. Is it going to be a year from when the temporary protective order was issued? Is it a year from when you're in court on the final order? Perhaps it's a year from the date that the interim or temporary order was served, as that's when the respondent is on notice. So again, we don't have the answers, but these are things that we've seen come up in our cases so far. And then finally, one additional tip we just wanted to share with everyone is consider whether you want to add any language to your retainer agreement vis-a-vis COVID-related restrictions. So do you want your retainer to include requirements that your client wears masks in court or when coming to your office for a meeting, or spelling out restrictions on who the client can bring to court with her or him, since we believe that the courts are going to be strictly limiting the number of people who can come in. So again, more questions than answers, but things that we hope that all of you will consider. With that, I'm going to turn things over to Mark to talk more about in-person and virtual hearings, and I'll start checking some of the questions that have been coming in the meantime.
Thank you, Deena. I was going to say, can everybody hear me? But I guess that's probably not going to be worthwhile. I can hear me, and I'm going to tell you that for me as a trial lawyer, this entire landscape has changed, and it is filled with uncertainty. And I don't want to just dwell on what we can't do, but I think it is worth thinking about how we are now going to view ourselves as litigators, because it has changed. What that means is that where before you might be looking at a quick solution or a trial, you're now going to be faced with the prospect of perhaps trying to be a mediator and to mediate your case much more than a litigator. And what I mean by that is that if other jurisdictions are going to be like Montgomery County, for instance, they're setting 4 cases per hour. And I'm assuming that since we're starting phase 2 on June 8th, and that these protective order cases, like a few others, are deemed emergencies, that all of them, unless I hear to the contrary, are going to be heard live in court. So if you're only assigned 15 minutes to resolve a case, how are you going to do that and be effective at your job? And of course, that's an imponderable we don't know. And one of the ways might be, for instance, and I don't typically do this, would be to try to contact the other side in advance. Just think about it. If you only have a certain amount of time to try your case, and you don't think you can successfully try it or effectively try it, then if you have a day or two to potentially try to work something out with the other side before you even get into the courthouse, that may be time well spent. And you have to calculate that against the idea of whether or not you're going to be revealing things to the other side that you don't want to share with them that may hurt your chances in trial or not. But I think it's going to require us to revisit our orientation about how we view our adversaries, because it may be a bit more of a communal setting than we're typically accustomed to when we're litigators and hoping to win the case and get the best results. The other, you should explain to your client everything you can think of and get their diminished expectations, and tell them that many things that you've heard about on TV or seen are not going to happen right away. And you may not get the kind of justice you want. And here's how it's going to go, and expect it will perhaps be a version of that, but don't expect everything. The other issue will be for trial lawyers, how, as either Deena or Laure said, how you're going to navigate your way around the courtroom, where you're going to stand, where you're going to move, how close you want to sit to your client, how close you want to hear your client when that client is speaking to you, how facile are you on your cell phone to try to text them, and other things. The other question I would have is, if you have certain type A judges, and I don't mean that disrespectfully, but that if I'm a judge and I have 4 cases in an hour and I have 2 lawyers on the other side and they're getting in my way, I'm going to step over them. I'm going to step over them because I have a docket to run and I have 1,000 cases to get through, or a portion of that. So you may want to be a bit more solicitous of a judge than you ordinarily would to find out what their comfort level is, so that you can at least ingratiate yourself to that judge and get them on your side, so that they know that you appreciate that their job is much more difficult. And so I think that that would be useful. And things that I've been thinking about as I've been listening to both of these two excellent speakers is leading questions and proffers and stipulations. Judge, I'd like to be able to lead my client because I only have so many minutes. And if you think I'm doing too much to suggest, then stop me, or something like that, where I wouldn't have done that before. Or naturally, stipulations would be welcome, but also just the idea that, Judge, I'm going to give you a proffer of what my client's going to say, if that is helpful to you, but I'd like her to testify. I mean, just think about a typical case, an assault case. Maybe there's a claim of self-defense. So one spouse says the respondent hit her, and then the spouse says self-defense. How are you going to do that in 15 minutes? I mean, you can't. So, Judge, I'd like to proffer some of this, or I'd like to lead to some of this. Is that okay? Again, I just don't know how all the
Hey, Mark. I think Mark, Deena, do you want to just pick up for us for a little bit? Mark, if you can hear us, why don't you go ahead and refresh your browser?
So Mark, if you're able to hear us, and Laure, can you send Mark a quick text?
Yeah.
Mark, unfortunately, your screen just froze, so we're missing all of the great information that you're probably saying in the background. I'll try to fill in as best I can while we get you back online. So going back to what Mark was saying, that, these cases are going to happen very quickly. And if you know you're in a contested posture, you may want to go ahead and request a postponement now. We don't know for sure how the courts are going to respond to those requests, but it may be that they will be more liberal with granting postponements, particularly if you have a case that is hotly contested and you know cannot be accomplished in 15 or 20 minutes. Similarly, if there are issues related to children, custody, access, or financial support in the form of emergency family maintenance, you may either want to request a postponement, or if there is an ongoing family law case, consider asking for the court to transfer the case to circuit so it can be heard there. They are obviously dealing with their own backlogs, but the majority, if not exclusively all of the cases right now, are in the district court because they've been coming in through the court commissioner. I think along the same lines, figure out what is the most important relief that you are trying to obtain for your client. So beyond just the issuance of the protective order, if you represent the petitioner, does the client really need a vacate? Does the client really need custody? Is emergency family maintenance something that you could put off until a later hearing, or possibly a child support action? If you're only going to get 15 minutes, you may need to prioritize the relief that you're asking for the client in that first instance, and then move on. If you're representing the respondent, is it really important to your client that the respondent see the children as expeditiously as possible? So you may need to be prioritizing that when you ask for relief. Sometimes you may be able to get more for your client if you're able to consent to things, but obviously you have to judge whether your client is comfortable with the consent and whether the consent agreement is in your client's best interest. But there may be things that we can all get for our clients, whether we represent petitioners or respondents, by consent, that we won't have the opportunity to in a contested hearing because the court's not going to give us enough time to litigate all of that. Don't forget, as was true before, it's true now that if your client has been charged with related criminal action, that there are some Fifth Amendment issues in play. And I think this is particularly important right now because the criminal case procedure has also been greatly affected and slowed down. And so where we might have used to see a fairly swift resolution of a criminal case, and so the Fifth Amendment issues might be resolved by the time you go for a final protective order hearing, criminal cases now are also taking a lot longer to resolve, and so they may be in play for a lot longer period of time, and while you're trying to deal with either resolving or litigating the protective order case. So make sure that you are thinking about that. With all of these, obviously the analysis that you engage in and how you want to deal with your case is very different if you have an opposing counsel versus if you're dealing with a self-represented litigant on the other side. And from the experience of the House of Ruth, we often are dealing with self-represented respondents. And so you just have to give consideration to how any of these factors change if you don't have opposing counsel.
I'm back. I don't know if I'm still allowed to participate.
Of course, Mark, welcome back. I see that you're on the phone. So just to catch you up, Mark, I kind of went ahead and finished out some of the points that we outlined in the in-person hearing section.
Sure.
So that you wanted to emphasize, and if not, move on to the remote hearings, and I'll go back to see what kind of questions we have.
Okay, forgive me. I'll do my best, and if it's been covered, then please stop me, and I'll move on to the next speaker. The aspect of filling out worksheets. So
no, we did not cover that yet.
Yes. So I've spoken to a few district court judges, and one of the things that they're very interested in is that lawyers are doing the work ahead of time to make their jobs easier. And that could consist of filling out either the temporary or final protective order worksheets, even if you don't know how the case is going to work out. So it saves the clerk time, and they very much appreciate that. Also, I found out in Montgomery County that the clerks have created some of these forms that are outside of the explicit language of the worksheets to save the clerk's time. And it may be things like, since there are no longer standbys because sheriffs are not participating in somebody removing their personal items, that the courts are now stepping in and requiring or suggesting to the litigants that they work out their own standby. So they need to have orders that specifically detail the process of that. And it's going to essentially be the same in each case, but it's not on the worksheet. So there may be a situation where courts themselves are creating forms separate and apart from the approved forms to facilitate that. I'm also hearing, in no particular order, that as I think it was Laure said, that cases with children, guns, etc., or weapons are taking priority. The other issue that's come up is that judges are saying, listen, that you have so many minutes. If you consent to a temporary protective order hearing, I'm going to give you an access schedule for visitation pending the final protective order hearing. But if you don't consent to the TPO, then you're going to run out of time and you're going to have to go elsewhere to try to figure out an access schedule to a final protective order hearing, which is pending, and it may be 2, 3, or 4 weeks. I don't know how much time it'll take to get there. So these decisions that you are now wrestling with are novel, and we're all in the same boat, but consenting may have more power than it used to. If you can't get the emergency family maintenance or access schedule and you're out of time, then the question becomes, why do you have to note an appeal? And it may not even be a final order. I'm not sure for purposes of noting an appeal. Couldn't you just get another date for EFM or access before your final protective order hearing or post final protective order hearing? I mean, I don't know how that'll work, but if you have a client who's basically said, I haven't seen my kids in a month since the interim was entered and I want to see them and there's no reason not to, how's that going to go? You may also want to be thinking about being creative and giving your client's children access to video conferencing to at least have access or make an offer to the other side when you've been denied access during a temporary protective order to either get that time made up at the tail end, or certainly at least have access electronically so that the missing parent can have access to their children. Those are all ways that we can work our powers to try to ameliorate a situation which really is quite taxing. I think that the only other point I wanted to make is that some have talked about the difference between non-MDEC and MDEC jurisdictions, and I was wondering, well, why that's really relevant. But it's occurred to me that in the non-MDEC jurisdictions, you're also going to be dealing with the clerks having to wrestle with all this paperwork that's been hand filed, that's been stacking up on their desk, as opposed to something electronically. And perhaps then that necessarily means in places like Prince George's and Montgomery and Baltimore City that there'll be fewer resources, that there'll be fewer clerks to be able to assist maybe judges, because they're now digging through those volumes of paperwork that they haven't had a chance to have access to. That's what I have for now.
Thank you. So we do have a couple of questions coming in. So an attorney from Anne Arundel County has been involved in some telephone hearings and would love to hear how practitioners are offering and admitting evidence during remote hearings. And it's kind of a three-part question: how to admit photos, how practitioners are showing the photos to the opposing party or counsel, and how they're getting their client through the authenticating questions when you can't put the photograph or the exhibit into your client's hands. So Mark or Laure, do either of you want to take a go at that question?
I haven't done a remote one, so Laure, you have.
Well, my staff has, and I mean, I can't give specifics, and I'm sorry about that, but I do recognize that it's been a changing issue. So first it was, in one jurisdiction it was, here's an email all of the evidence in advance to this email address, and it'll go to the court and opposing counsel, which presents difficulties and is not all that great of an idea in my view. Then we heard from another court, well, if the litigant's pro se and they have evidence, they can just fax it in. And until I hung up and went to bed, and at about 1 o'clock in the morning that night, I thought, wait a minute, I don't have a fax machine in my home office. How is a pro se litigant who usually only has a phone? And when we talk about technology, that's a big, big issue that you all are going to have to grapple with, which is, at least most of our clients are low income, and most of them have a phone, but they don't have a computer, a printer, a fax machine in their home. And I think we took that to the attention of that court, and they were going to develop an email way for people to submit evidence. And, if you can stipulate to any evidence in advance, I think that would be really, really helpful. Probably can't do that with a self-represented litigant. I think there were other ways that courts were trying to figure this out. So as to the authentication questions, because I haven't done it, I don't actually know what people are doing. Do you know, Deena?
I don't. I know in some of the remote hearings that I've heard about that the attorneys have had to send in the evidence in advance. And so I don't know if they're still going through every authentication question with the client and just sort of referring the judge to, we're talking about exhibit 1 right now, which is a photograph, and, eliciting questions in that way. I think this is one of the things that's really going to develop over the next couple of weeks and months is the best practices for that. So I would say try it and then let us know how, please. We would love to hear what you all develop for handling these. I can say that what I'm hearing is that a lot of the courts are going to try to do some of these hearings in person over the first few weeks. So starting on June 8th. So it may be that the remote admission of evidence isn't as much of an issue, but it is something that you're going to have to think through. So it may be that, you need to make sure that your client has a copy of each of the documents that you're intending to admit in advance. And even in person, you need to be aware that if you're trying to show the court text messages, and in the past you would have just handed the court your phone or your client's phone to look at the text messages, you're not going to be doing that. The judges are not going to want to touch the phone. So if you want to put evidence in, you need to have it printed and marked in advance.
Can I say one thing?
Yeah, please, Mark.
I personally, well, I haven't tried any hearings remotely. I just don't know how anybody can do justice to testimony, as particularly cross-examination, remotely. I just don't know. I mean, if you have no other choice and you have to, but I would eschew that against a continuance or some other way to be live.
Absolutely. A question asking us to clarify whether the 15-minute timeline or time limit applies to both district court and circuit court. So for the time being, the vast majority of these cases, if not all of them, are going to be in the district court because they've come in through the commissioner's office, and so they'll automatically track into the district court system. The circuit court won't begin hearing original protective orders, I think, until July, if I'm not mistaken.
July 20th.
July
It's
20th.
phase 2 of the Judge Barbera's order from Friday.
So, and the 15-minute time limit is what we're hearing from some judges in some of the jurisdictions. But again, this is going to be very specific jurisdiction by jurisdiction. It may even vary from judge to judge.
But it also may make sense. Sorry for interrupting. It's hard and I can't see you. Is to think of a way to get into circuit court. I mean, that may mean filing family actions when you might not have, to get the cases transferred from district court to circuit court so you get more time.
Right. We got a question, have any of the judges discussed emergency family maintenance payments in light of the potential difficulty for residents to find alternative housing due to rental restrictions or family and friends not wanting to house a person due to COVID issues? I can't speak to whether any judges have discussed that, but I think it is a valid concern and issue. Obviously, the impact, from my point of view, the impact of COVID is it's making it harder for either petitioners or respondents to find alternative housing. And so depending on who you represent, the either advocating for or advocating against the vacate is much more important, because there aren't other places to go. And, you know, people have lost employment or have been furloughed, may, you know, have limited ability to pay to rents, you know, at the vacated home and the new home. So I think these are all considerations that are definitely going to play out. Laure, it looked like you had something to say.
I was going to say, anecdotally, I have, because we have a hotline and whatnot, so I talk to a lot of anonymous people, essentially. I've heard about peace orders where they're not vacating, or they're not, you know, or protective orders where they're not vacating the roommate, for example. They're just saying, stay away from your roommate's bedroom. And they are not doing the standbys, as Mark mentioned. So it really is an entirely different universe in many ways. But I, of course, think, and of course, family law practitioners are going to deal with this in child support, contempt cases, and everything else, the inability to pay because you're out of work. And I think that it remains to be seen what's going to happen with all of that. And like Deena says, I make my argument the best I can, depending upon which side I was representing. I just wanted to tell a colleague, former employee of the Women's Law Center, texted me just now. I just want to relate what she said, which is, she says a lot of the district court judges aren't taking the exhibits. One had her read the police report out loud rather than touching it, essentially. And she was in person in court in Baltimore County District Court. So I think, you know, I go back to what our takeaway is, which is we really don't know what's going to happen. And it seems to be very different in MDEC, non-MDEC, you know, different district courts in different counties, different judges in those district courts. And so you just talk about having to be on your toes and adjust to whatever eventuality the judge who has control of the room brings is part is now a bigger part of our job than it ever was before.
And I would also, just for those listening, I mean, the temptation to want to become apologists for the way the system is created is very tempting, but I think that sometimes you may end up just having to say, this is just as frustrating for me. I am doing the best I can, but we are dealing with a very unusual situation that hasn't happened in our lifetime.
Right, it is quite literally unprecedented. And I think everybody, even the client, has to understand that at some point.
Absolutely. So I'm seeing one last question that's been posted so far. Any thought to the parties submitting memoranda to the court before the abbreviated hearing? So if the author of that question is still on and wants to clarify, I'm not sure to what end. I guess I could speculate and think, a memoranda outlining the relief that the client is seeking, or outlining, the factors that you think contribute to the vacate, let's say, or the custody request that you're making. I hadn't considered that until that was raised, but it certainly could be one approach. I don't know how the courts will entertain that, but any creative way of approaching these cases right now is something worth considering.
The other point I'm thinking of is in terms of fee setting, and this may not affect all of you, but how are you going to figure out if you're charging flat fees versus hourly fees, how you're going to structure a fee? And you need to think about creative ways that reflect the nature of the work you're doing and the uncertainty of what you're about to do. And I know many people are not fans of hourly work, but that is an opportunity to revisit that, because it is this imponderable where you don't know what's going to be expected of you. Or can you just enter a limited appearance? Can you enter a limited appearance for just a temporary protective order because you don't know how much time it's going to take, and you keep entering piecemeal? I don't think there's anything that prohibits that, but I'm just throwing that out there.
All right. I'm seeing a couple of, comments pop up. Thank you for doing this. This has been the most practical and useful webinar I've seen in these days of thousands of webinars. Thank you for that very much. We appreciate it. I guess sometimes being not fully helpful is what's most helpful. At least that's the way we tried to approach this, is that we don't have all of the answers, but we do have lots of questions for all of us to consider. And then another comment, this is very helpful. Thank you. The comments and suggestions are valuable, both specifically and in general. We really appreciate all of you taking the time to sign into this. Speaking for myself and Laure and Mark, I think this is fair to say that, we take these cases incredibly seriously. People's safety and lives are at stake. And so we appreciate everyone taking the time to meet with us today. We wish you the best in the cases that you end up handling, and, wish continued safety and good health to you and all of your families. I believe that our email addresses are all available through this presentation, and if not, we're all searchable through the internet, and we welcome you all to reach out to us with any additional questions or concerns, and if we can be of assistance as we go into yet another great unknown. So if there's nothing else from any of the speakers, and I'm not seeing any other, I'm sorry, I am seeing some additional comments and questions. Please comment on how the filing of temporary protective orders has changed how they're being heard, and whether interim protective orders are being issued. So all of the cases right now are originating as interim protective orders through the court commissioners. The district courts are not the original point of entry for temporary protective orders right now and will not be until July 20th. And that's per Judge Barbera's order. So they are all beginning as interim protective orders. During the past couple of months, while the courts have been partially closed, the courts have been reviewing the interim protective orders and calling in cases for temporary protective order hearings that they feel have an immediate need, and those are being prioritized as cases that involve vacate of a home, custody, or removal of firearms. So the cases that are scheduled for June 8th and beyond are a mix of temporary and final protective order hearings. I hope that answers the question. Mark, I think Laure had to jump off. She had another meeting at 2 o'clock. Mark, did you want to add anything to what I just said?
Mark, you're currently muted.
Mark, if you can hear me, you're muted. Still muted, Mark.
Sure. So
There you
are there any more questions? I'm not sure.
Yeah, there's a couple more questions. What about referrals to DSS based on allegations of child abuse? Is the hearing held in abeyance waiting for a report? I haven't encountered that yet. I know in quote unquote normal times, if there's been a DSS investigation ordered and it's not available at the time of the final protective order hearing, we would usually ask for a postponement to give DSS more time to complete those reports. I don't know what that's going to look like. I imagine that DSS is also struggling with backlogs and trying to reach people given all the restrictions. So I don't know if courts are going to be more restrictive about which cases get referred to DSS, and if it will take, I would imagine it would take DSS longer to turn around a report. So that may be yet another reason that you would want to request a postponement.
But at the same time, I mean, if you're in court, and so if the DSS report is not ready, then that would be the time to ask for whatever relief you think you can squeeze out of the judge at that time. Could it be, if it's a temporary, some kind of access schedule or anything creative, which either you think might build a bridge for purposes of settlement down the road, or just something where the judge can put their fingers in it to get you just some movement, so you're not at bereft pending the outcome of a DSS report.
Thank you. So I'm seeing one final question, unless anything pops up in the interim, we'll try to answer that. And then I think we are at our time. Mark, this speaks, I think, to what you were saying earlier. What if opposing counsel or pro se litigant does not cooperate with a request for stipulations? How would you handle that? And what's the likelihood of a continuance in that situation?
Well, are you saying you if they're not cooperating and getting stipulations, that would be a basis of a continuance? I don't think so. But in terms of stipulations, I think that if you can't make somebody stipulate, but you can certainly make them look bad in front of the court. If you're saying, Judge, we're trying to streamline the case, and here are the 3 or 4 areas that I'd like to have stipulations to, and we have not been able to come to an agreement, I think a judge will look across their glasses at opposing counsel and saying, are you serious? You can't stipulate to these things? I think that would be the way to pressure them. But I think the more that you are trying to truncate the hearing for the judge will probably be met with favor from a court that's struggling.
Okay. And then I just got a follow up to one of the earlier questions, whether petitioners for interim protective orders have to appear in person at the commissioner's office, whether those offices are still open with the same hours and taking precautions. So yes, A petitioner does have to appear in person at a commissioner's office to apply for the interim protective order. Different commissioners are handling it different ways. We've heard that some of the commissioners' locations are having clients or petitioners, come in, get the forms, return to their car and sit in their car to fill out the paperwork and then come in to finish the process, but they're not having people sort of wait while they're filling out the papers inside the actual commissioner's office. The commissioners are available, as far as I understand, 24/7. And yes, it's been our understanding all this time that they have been taking precautions, as I just mentioned. And again, it's our understanding that that people will continue to file cases in the first instance at the commissioner's office, and that during these initial several weeks, while the courts are trying to clear the backlog of cases that have come in since the courts partially closed in March, that they will also be hearing temporary protective orders that come in through as interims through the commissioner. But it may not be within 48 business hours the way it normally would, and that petitioners will not be able to begin filing temporary orders in the courts until July 20th.
I also know, I'm looking through Judge Barbera's May 22nd order to see whether there's some way to squeeze out a case in the circuit court, a protective order case. And it would not be an impossible situation if you felt that there was some emergency that warranted the circuit court's involvement with the absence of a family case, that you couldn't file something to seek if the court gave you leave to file. I mean, I know that's overkill, but don't necessarily treat it as a dead end.
Okay. All right. Well, I want to thank all of you again for joining us. In her absence, Laure and Mark, with you back here on video, thank you so much for participating in this hearing. And we want to thank Andrea and Bill and Chriselle and Shally from the MSBA for inviting us to speak with all of you this afternoon. So be well and stay safe.
Bye. Thank you, everybody.